Good morning. My name is Brooke Evans and I'm an attorney with the Finklea Law Firm in Florence, South Carolina. Today I'm going to talk to you about annulment. Annulment, as opposed to divorce, is a way of declaring a marriage null and void. It's as if the marriage never happened since it was invalid from its inception. There are 6 specific grounds for annulment in South Carolina. The most common that people refer to is the failure to consummate a marriage. However, that can be one of the most difficult to prove if the husband and wife have actually lived together since the marriage. In South Carolina, if you have actually lived together, then the court may consider the marriage ratified and will not grant an annulment on that ground. The other 5 grounds for annulment are underage marriage. In South Carolina, one must be 18 years old or have parental consent to marry. If you are under the age of 18 and you failed to get parental consent, then the marriage can be annulled since you were not legally able to enter into it in the first place. The second ground I want to talk about is bigamy. Obviously in South Carolina, you are only permitted to be married to one person at a time. If either the husband or the wife is legally married to another at the time of the second marriage, then the marriage is void and can be annulled. Mental incapacity is another grounds for annulment. If you or your spouse was suffering from some type of legally recognized form of mental incapacitation that would have rendered you unable to enter into the marriage, then that marriage can be void. Duress is a similar grounds for annulment. If the marriage was entered into under the threat of force, either spouse can apply for an annulment in South Carolina. Now, the ground I want to really talk about today is the fraud-based ground. This is a very case-by-case basis, but South Carolina does put some limitations on it. A marriage that has occurred under fraudulent terms can be annulled in South Carolina. One example that I give to people is if a woman says that she is pregnant with her future husband's child, and he marries her for that reason, and it turns out that the child is not his, the marriage can be annulled based on fraud. Now, our courts have limited a few things that cannot be used to get an annulment based on fraud. Fraudulent representations regarding one's character, social standing, or fortune do not constitute fraud significant to entitle the parties to an annulment. So just to recap, annulment is different from divorce in that annulment basically says the marriage never existed. There are 6 particular grounds, but most of them need to be looked at on a case-to-case basis. If you have any questions, please contact Brooke Evans at the Finklea Law Firm. Thanks and have a great day.